ahead and fire up the virtual meeting. Okay, we're live. Mark, would you please call roll?
Representative Banks.
Aye, here.
Representative Conrad.
Here.
Representative Heiner.
Here.
Representative Knapp.
Here.
Representative Larson.
Here.
Representative Lawley.
Excused.
Representative Tarver.
Here.
Representative Western. Chairman Burkhart.
Here.
Thank you.
Okay, we have a quorum. Just a couple opening remarks. Remember, I'm pretty tough on keeping things in line and keep the decorum of the committee and the debate. You're free to say whatever you need to say, but please be respectful of others. One thing that has come up lately is people straying off subject. For the people here in the room, those virtually, if you stray off the subject, I'll give you one warning, and the second time you'll be done. We need to stay on target, on subject, and handle these bills. We've got 3 good substantial bills that have a big impact on the state and the people of the state, and we need to get through them today. So any questions? And I'll give you my usual, which is get out of line, I throw you out. So Representative Western, first bill up for our consideration is, where's my list? I believe this is Senate File 50. Representative Western has already assumed the position, so please proceed.
Thank you, Mr. Chairman. Certainly hope you don't throw me out.
No, you're usually pretty pleasant.
Thank you, Mr. Chairman. Members, so I bring to you Senate File 50, and it's, kind of the joke I say is the buzzword is DUNA, as in do not hesitate to vote for this bill. But obviously, there's a lot going on here. I know it's 46 pages, which is a little intimidating, but I want to kind of give you guys some context of why it's here, why it's important, and how Wyoming benefits. So if you recall, a couple of years ago, we passed our DAO bill, the Decentralized Autonomous Organization. It's a new LLC option for incorporation and filing in the state of Wyoming. We've had hundreds use that option since, and so this is tacking on to that. And just to kind of get it out of the way, I mean, the reason it's 46 pages is, if you look at the DAO bill, it was also quite lengthy. The reason this one is also lengthy is because it's copying most of that language, probably 90% of it, and putting it into a new chapter, which is chapter 32, as you can see there. The reason we did that is because DAOs LLCs are specifically for, at least in theory, to maximize profit on behalf of the LLC, the DAO, and its owners. Where with a nonprofit, obviously, it is not the explicit objective to maximize profit, rather for other means and objectives. So that's kind of the reason why you're seeing in the form it is and its length. If this was a standalone bill of new language, it would probably only be a couple of pages. So kind of what a DUNA is and how it functions is it's kind of like an HOA is the best analogy I can think of here that we can understand. An HOA exists not necessarily to make money, but to manage an organization of legal entities and properties that we all own. They collect enough revenue to pay for mowing, snow removal, that kind of stuff, but the HOA itself is not designed to make money. More or less, that's kind of what you're seeing here with this DUNA, right? So the DUNA itself obviously needs to generate enough revenue for costs associated with management, filings, administration, all that kind of stuff. But the actual enterprise itself is not designed to make money. Some of its members, of course, absolutely can. Again, let's take the HOA example. You can have a property, let's say you want to build a shop. So you can, if you practice carpentry and have a business that way. It allows for that type of structure, but for the actual DUNA itself, it's not explicitly designed to generate revenue. Mr. Chairman, obviously it's pretty long. I don't know if going through this thing page by page is, given the hour we have and the workload we have, but want me to go through it section by section, or how would you like me to approach this?
Representative, yes, at least go through, in broad terms, section by section, what it does.
Sure.
Why you have it doing it that way.
Sure.
Just so the committee understands and the
Absolutely.
audience understands.
And I think I wanted to maybe elaborate a little bit also on how this benefits Wyoming. If you look at just internet traffic broadly, we're been on this trend where the majority of it is really being either influenced or outright controlled by a small handful of some of these mega tech companies, obviously Google, Facebook, those types of entities. And so this kind of decentralized technology approach using blockchain technology, it provides an alternative, and there's a lot of businesses and opportunities in that space, I think, that wants to take advantage of these types of options, right? So some of them are some of these internet protocols or some of these exchanges that this type of incorporation is potentially really beneficial, right? Some of these exchanges, for example, there's a big one called Uniswap right now, and others where they don't have an ideal legal home, a place that they can incorporate and engage in legal formation that really fits their needs. And so I think that's what this bill really does, is that it offers them that opportunity to incorporate in a way that fits their needs. And what it really comes down to is governance, is they want to be able to govern these organizations and its participating members in a way that allows them to really fulfill their, the model that they're trying to execute on. So I think that's kind of the big picture context here. So we'll just go through this section by section on page 1. 102 is definitions, obviously. I think one of the key concepts here is that administrator concept. So when you form an LLC, you have an operating agreement, you usually have a member manager or a manager in those LLCs. Again, those ones have a lot of influence over revenue generation, business decisions, that kind of stuff. The administrator concept that it talks about right there on page 2, that's more of, it's kind of like a clerk, right? They're just making sure that things are filed properly, taxes get paid, that kind of stuff, where it has less influence on the kind of overall direction of the organization, and more so just kind of making sure that things are functioning properly and that the T's are crossed and I's are dotted. So that's an important component here. So if we keep going through some of those definitions, see on to section 103 on page, let's see, that's bottom of page 6. This talks about obviously the governing law. These DAOs operate and these DUNAs operate through smart contracts. And obviously I'm not a technical expert. I think there's some folks here in the room that can go a little bit deeper dive on that. But these smart contracts are executed based on the algorithms that they're constructed and how they're supposed to operate. So if you're an exchange for some of these digital assets, these exchanges or these transactions are executed on a smart contract. And so this section simply talks about is how those are structured legally when these DUNAs are formed. Section 104 talks about, obviously, because it's a nonprofit, prohibitions on distributions of dividends, compensation, and that kind of stuff, talking about explicitly how those funds are handled within the DUNA. Moving on to section 105, this talks about the type of property, real and personal. Section 106, statement of authority, how those assets are governed within the DUNA. Keep going to page 12, section 107 talks about liability, saying that the liability really rests with the DUNA. So just because you're a member doesn't mean that you're legally on the hook or that you bear some of that liability. Moving on to 108, capacity to defend itself in the court of law, saying that it does have standing, and that generally it would be the administrator that gets served those types of documents. The effective judgment of order. Section 110 at the bottom of page 15, it would be the administrator of the DUNA that would receive those types of filings and documents if they are served for any kind of civil litigation. Moving on to section 111, summons and complaint. Obviously, again, that would usually, most cases, that would be the administrator of the DUNA. Section 112, again, talks about the administrator being the designated person for the DUNA. Section 113 talks about the venue for any sort of arbitration or litigation. Section 114 talks about repeal, dissolution, the protocol for those types of measures and actions. You'll also notice, let's see, the top of page 20, generally it's 100 members or unless otherwise explicitly permitted. This is, again, one of the things that was talked about in the DAO legislation that we passed a couple of years ago. Section 115 talks about admitting new members, expelling new members, that kind of process within the DUNA. 116 talks about member resignation. 117 talks about the duties of members. I will say, and some of these types of these DUNAs that exist now are the companies that take advantage of this. Some of them, their membership is changing daily in big numbers. Sometimes it's tens of thousands of new members are coming on, tens of thousands are leaving. So there's a lot of fluctuation. I think giving them the ability to manage that process of onboarding and exiting members is important. Section 118 on page 23 talks about the agency powers of members, which means just because you are a member of ADUNA doesn't mean you have the ability to make legal decisions on behalf of the ADUNA. Section 119 talks about transferability amongst members and interests, and Section 120, page 24 talks about the approval of members. Keep going down to Section 121 on page 25. This really talks about the utilization of blockchain technology, AKA distributed ledger technology. Keep going down to page 27, Section 122 talks about this consensus formation algorithms. Obviously, if some of these DUNAs, have hundreds of thousands of members, consensus is a really important decision because that's how decisions are made for the entity as a whole. And so this kind of talks about that process of how they, that governance and getting consensus within these smart contracts and these organizations. Section 123 talks about how we pick administrators and their duties and rights and obligations. Keep going down. Section 124 on page 30. This talks about record inspection, record retention, all that kind of stuff. Again, this is language that was copied exactly from the Dow legislation from a couple of years ago. If we keep going, Section 125 on page 32. Obviously, identification, expense management on behalf of the DUNA. Section on page 34, Section 126. This talks about obviously the termination in the event that the DUNA members choose that option. Section, page 37 talks about mergers in the event that there's a merger or an acquisition option. Keep going down through page 39 through 40. So trying to find the next section here, Mr. Chairman. On page 45, Section 120 talks about conversion entities. Let's see. Then, of course, on page 46, supplemental principles of law, and then, of course, on line 12 on the last page talks about the effective date. So I know obviously we just covered a lot of ground right there. I just wanted to kind of give you guys a walkthrough. So, Mr. Chairman, if there are any questions, I'd be happy to answer them.
One moment, Representative Heiner. So how many people in the audience wish to speak on this bill? I'm just curious. 1, 2, 3. Okay. What I would ask you is, as you hear the questions from the committee, if you feel you have additional information, please keep that in mind when you come up. Just for the edification of the committee, if you would. Representative Western?
Mr. Chairman, with your consent, would it be okay if they came up here now, just help answer some of these questions, or do you want to do it sequentially?
No, that'd be fine. Yeah, please, come on up. Okay, and sorry, somebody's gonna have to pull one of those terrible plastic chairs up with you, or just sit in the background. So that would be great. So with that, Representative Heiner.
Thank you, Mr. Chairman. So, excuse me, at DUNA, it looks like the filing fee is $5. Is there a lot of work for our Secretary of State's office for these filings and only being compensated $5? Is it going to be much of a revenue generator for us?
Representative, or who wants to answer? Okay, when you do, if you'd please identify yourself, who you represent for the record, that'd be great.
Colin Crossman, I represent the Secretary of State's Office Business Division. Mr. Chairman, Mr. Representative, because of the nature of these, we don't anticipate a load on the office much at all. We already have a filing category for unincorporated nonprofits, and this would fit in with that. In addition, there is no specific requirement that these be filed with our office to exist. That's part of the concept of unincorporated. They may choose to file with our office to get additional recognition, such as the ability to transact in real property inside the state of Wyoming, but their existence is not contingent on filing with our office. So unincorporated nonprofits do this now, but all they are filing with us is the appointment of a registered agent or the appointment of an agent for the purposes of transacting in real property. Those are the only two things they file with us. And so we don't anticipate much filing activity in our office because of that. And the filing activity that we do get would be able to be handled by the current system with a single change, adding a indicator that it is a DUNA, not just a non-incorporated nonprofit.
Follow-up?
Yes, thank you, Mr. Chairman. So could you explain what the benefit to Wyoming and its citizens for this additional, having a DUNA in Wyoming? What's the benefit then? The filing fee is minimal, the revenue is going to be minimal. Explain to us why we want to do this.
Whoever would like to take that, please.
Pardon. My name's David Kerr. I represent my own consulting practice called Cowrie. I work with Miles and Brian at A16Z quite a bit. And I drafted a model law on the DUNA that the Wyoming section is largely based off of. So I think I can speak to the $5 question. The reason why it was labeled at $5 was because the existing Wyoming UNA had that same limitation on it. So wherever possible, we took the same exact filing fee, we took the same exact language and placed it in, so it was identical. So to the point of, could it produce more revenue? It certainly could. There's not a prohibition on raising that fee. That was done for consistency. In terms of the larger question, as far as benefit to Wyoming, there's a number. It's difficult in a state that doesn't have an income tax at the corporate level to point to direct revenue coming in, because obviously revenue itself doesn't have the same tax benefit it does in other states and at the federal level. But what it does have is, right now there's this very large kind of quagmire of where these entities should be. And Wyoming took a very big step with its Dow LLC to kind of provide a home to those legislations. And it's consistent with what it did, being the first state to adopt the UNA in the first place, being the first state to adopt the LLC. There's an opportunity to kind of lead the way on business development. And so there's an opportunity for the court systems to become involved, for the industry to evolve around that, much like Delaware has done at the Chancery courts. Wyoming is growing its Chancery courts the same. And so there's an opportunity for the administration of these entities to come someplace, and having a home where there's a law that speaks to their issues directly is very helpful to that front. And then there's also a fact that even though these entities exist all over the world, it's kind of a requirement that to the degree they have in-person meetings, to the degree they have physical nexus, that would need to be in Wyoming. And so there's also the path to the money that would be generated through these businesses, these groups meeting here and having activities here. So the travel benefits here, the tourism benefits, the influx of funding around the institutions, having a place to go for the law will drive in the investment dollars and then also the operations.
Representative Conrad.
My question was answered. Thank you, Mr. Chairman.
Okay. Other questions? Other questions? Representative Knapp.
Representative, I think I asked this question when the Dow came up too, but so these are organizations kind of defined for charitable purposes, which means any purpose of an organization that has attained exemption under the section 501c3. And then it also goes into, although these are not-for-profit, they may engage in profit-making activities, but profit from activities shall be used in the nonprofit association's common nonprofit purpose. And I know it's a stretch, but is an unintended consequence of this that those organizations may be actually political in nature and affect things that way while having the, I think, the blanket of authority under this?
Representative, or, okay, whoever wishes. And if I might ask, because we're switching between the five of you, just each time you speak, if you just identify yourself again for the record.
Again, it's David Kerr with Cowrie. To the question about it being charitable purpose being a requirement, the definition of charitable purpose is primarily used in the mergers section. And the reason for that is there's a public policy requirement that if an entity were to hold itself out as a charity and solicit donations from the public or take advantage of the liability protections that charities get, then you wouldn't want to be able to merge into another form of entity without the Secretary of State's office or the Attorney General's office through the courts getting approval that that's appropriate. At a baseline level, the charitable purpose is not the requirement for this, it's nonprofit, which means it limits distributions. And so it's not a funding measure, but it's not necessarily tax exempt. So in Wyoming, that doesn't matter so much because like we said, no, direct tax revenue at the state level. And so, but at the federal level, it would matter. It would not need to pass the 501c3 or 501c4 or any of the 501c tax exempt requirements to exist. It would have to follow the rules of having more than 100 members, limiting its distributions, and following the laws as laid out by Wyoming. To the degree that it could be utilized as a funding source for political purposes, that's generally done under a tax exempt umbrella under a 501c4 organization. One of these organizations could most likely qualify as a 501c4, and that's where lobbying work is typically done. So it's possible. I would say that's not the intended use for it, and the reason why is 501c4 exemptions usually require, even though it's not written into the federal, international, or the IRS, the IRC rules, that it has a board that it requires centralization. The reality is to get 501c exemption at a tax exempt level, you do need to have a board or something functioning as a board. So these decentralized entities probably wouldn't be up to the task of getting the 501c qualification. And it was simply written in for a matter of completeness, and because the public policy around protecting 501c3 and citizens' relationship with that's so important, that's where the charitable purpose came from.
Other questions, committee? Okay, well, I do have one, and Mr. Kerr, you alluded to it. In here, we specify 501c3 organizations. Now, that kind of limits it to just those organizations. Is that something we want to do, or do we need to expand it out? Because there are numerous various sections for charitable organizations, or for right now, do we need to leave it at a 501c3?
Mr. Chairman, to answer the question, what I would say is it doesn't limit it to the 501c3, it's just that definition's very limiting. And so the fact that the definition's alphabetical order, it rises to a level of prominence it doesn't necessarily have in the bill. And so if you go further down the definitions, this definition for what is a DUNA, that would be kind of the controlling definition. It's the 100 members and it's the prohibition on distributions. That's what gives it its common nonprofit purpose. And so the law would require a common nonprofit purpose. That's the baseline. And so the charitable is something that it can attain, and if it does attain it, it needs to follow certain rules to be consistent with Wyoming's Nonprofit Corporation Act and the treatment of nonprofits who've attained tax exemption generally.
Okay, but excuse me, but my point is we specify in writing in the statute 501(c), and as the good representative knows, I'm kind of a stickler and we follow the law, which to me would preclude, because it's called out specifically, anything else. Now, is that the intent, or do we need to expand this or leave it as it is and get this off the ground and then look at modifying it later? Because you define charitable purpose as being a 501c3 organization.
Right, and the requirement for it.
Go ahead,
I'm sorry, Mr. Chairman, I didn't mean to interrupt.
No, that's fine. Go ahead, Mr. Kerr.
So the 501c3 would be defined as charitable purpose, but the DUNA would be a requirement of a common nonprofit purpose, and that is not a charitable purpose. So it's this very kind of vernacular, heavy, nuanced distinction that exists in entity law. And so when it does require, when an entity has risen to the level of attaining the 501c3 requirements, it's been afforded certain benefits, and it needs to treat those benefits with respect. But the baseline function for the law would require a common nonprofit purpose. That's what's in the definitions, and that's how it's defined.
All right, thank you.
Chairman, if I may
Yes,
add,
please.
I'm Miles Jennings. I'm from Andreessen Horowitz, which is a large venture capital fund that is very invested in this space and many others. We invest in startups, so usually two engineers coming out of college, and we have $35 billion under management within the digital asset space. We have about $8 billion under management. With what Mr. Kerr was just saying, I think the point to remember is the definition of what a decentralized unincorporated nonprofit association is does not require that it has that charitable purpose. The charitable purpose definition, as he mentioned earlier, is only referencing in the mergers and acquisitions area, and as a result, that's where the 501c3 definition comes into. So this statute does not limit its use to organizations that are only 501c3 qualified.
Okay, thank you. So, other questions? Representative Conrad.
Mr. Chairman, thank you, and I apologize for the question in advance. can you explain to me, is there a relationship between a DUNA and a DAO, DAO? And what is that relationship? I apologize.
Please, whoever. Again, just each time, if you would, just for the record, so that we're clear, it helps staff. Sure. Keep track of the.
Again, my name is Miles Jennings. So right now, what you have with a lot of these organizations is they don't have a legal entity structure. So they basically, you form a group of people that are managing technology that is on a blockchain. I won't get into the details of how blockchains function, but you can think of it as just a collection of computers that are all connected to one another via the internet. And so what they basically can agree how that software should run, right? And as a result of that, there are, people that would say, well, that looks a lot like running a business, and some would say that it doesn't. And so as a result of that, right, these decentralized autonomous organizations are somewhat in the ether. They don't really have a home. They don't have, legal incorporation status. As a result of that, that comes with, several risks to them. They don't have legal existence, which means you can't contract with third parties. You don't exist in the real world, essentially. You can't pay taxes, right? So to the extent that that software is generating revenues and profits, there's no entity to file tax returns. And then there's no limited liability. As a result of that, any member is potentially liable for the other actions of another member. So, for instance, right now, there is a case in California against a DAO that basically alleges that a single, a holder of the digital asset of that DAO, so for instance, like the holder of a Bitcoin, is liable for the actions of another holder of a digital asset of Bitcoin. That is a crazy scenario, right? In that it would be like if you held gold, that you could be liable for the actions of anyone else that held gold. So as a result of that, the DUNA legal entity structure, right, is an opportunity for these DAOs to select a legal entity in Wyoming and provide it with, solving those three problems. It would provide them with legal existence, so they could interact with the world. As he was saying, that they would be able to have an agent for service of process here. They would be able to be represented in court here. They would have the ability to pay taxes, and then they would also provide limited liability for the people that were participating in that organization.
Follow-up?
Thank you, Mr. Chairman. And I guess it's my second question or follow-up stems from the previous representative who spoke about costs in terms of filing. It's interesting that now the DAO, according to the state of Wyoming, a DAO registration initial filing fee is $100. So is there any sort of comparison, or why do we have a initial filing fee of $100 versus this in the DUNA arena as a difference? Should they be the same, or should they be consistent, or not?
No, please.
Colin Crossman with the Secretary of State's office. So the DAO is a special form of an LLC. And so its filing fee is related to the LLC's filing fee. And in that case, there is a lot more involvement in checking various things on the articles. We're making sure that they have a registered agent. We're making sure that that at least in the case of a DAO, that they have provided us the extra requirements. So there's a little bit more to it in that case, whereas in a unincorporated nonprofit traditionally, and in the DUNA now, the formation of the entity is not linked to filing with our office. Our office is merely providing a recognition of an entity that is formed outside of our purview. So similarly, if you were to go and create a sole proprietorship, you don't need to file with our office anything. Now you can, and similarly with a sole proprietorship, it would just be a registration for service of process. So in that case, that particular form is $5 for everyone. An LLC who is already formed, changing their agent for service is $5. So that's why that particular fee is being charged, because it's that form that's being used.
Mr. Chairman, if I can,
Jennings, please.
yeah, if I can add on that, again, my name is Miles Jennings. I think one of the things I wanted to just clarify there is that when I was speaking to what a DAO is, right, I was referring to the organization, not Wyoming's legal entity statute that it created for DAOs, which is a DAO LLC. One way to conceptualize this bill versus that bill is that this is a digital nonprofit, and that was a digital LLC.
Follow-up?
And just thank you, Mr. Chairman, for clarity. Said differently, a DAO is more labor intensive than a DUNA in terms of work required to register.
Yeah, Colin Grossman, Secretary of State's Office. Mr. Chairman, Mr. Representative, yes, I believe that is the case.
Thank you.
Let's go with Representative Larson first.
Thank you, Mr. Chairman. In relation to the $5 fee, is that consistent with other states for nonprofit or even DUNA registrations?
Colin Crossman, Secretary of State's Office. Mr. Chairman, Mr. Representative, I don't know how other states handle unincorporated nonprofits. I believe that our fee in that case would be relatively consistent. As I said, unincorporated nonprofits are not required to register in any way unless they are desiring to do so for the purposes of getting a registered agent or something else. But when you look at standard nonprofit corporations, those entities, I believe, pay $50 for their registration. And so there is generally speaking, a reduced charge for nonprofits in general, but those are incorporated nonprofits, not unincorporated nonprofits.
If I may speak,
Representative Heiner?
if I may speak to that in a little more.
Oh, I'm sorry. Go ahead, Mr. Kerr, please.
Mr. Kerr, again, speaking to that last point in a little more detail. The fee structure is similar, but because Wyoming did go first, it learns the lesson of going first. And so when they passed the Wyoming UNA in 1993, they enumerated $5 and kind of set it in time. The trend, the 5 years after that, when they started adopting, was to say a reasonable fee. And so it's crept up. And so it's crept up over time to keep up with inflation, but it's still well under $100 in total across statutes. But a lot of states kind of gave themselves a little more wiggle room than Wyoming did.
Representative Heiner.
Thank you, Mr. Chairman. Mr. Kerr, a little while ago, you mentioned some of the benefits to the state of Wyoming. One of them is that it would bring some court cases to the state of Wyoming, Chancery Court, and be able to help the state that way. But our court system is pretty full right now. In fact, we're adding personnel this year and additional costs because it is full and the docket is pretty stacked. So explain to me how this would help us with additional court cases and maybe an estimate how many more court cases we can envision, because we may have to staff up for that. Or Mr. Jennings.
Mr. Jennings, I think you're anxious to answer that one.
Yeah, sure. So I'm general counsel at A16Z Fund, so I have the unfortunate reality of dealing with a lot of the ongoing litigation that is in the space and have a view of kind of what will happen. I think if taking a step back, we're talking a lot about fees and stuff, and I think that, the current paradigm that exists with these companies that don't have a legal entity structure that they're setting up, as a result of that, they're working with law firms spending hundreds of thousands of dollars to set up their initial entity structures. These structures involve setting up foundations in the Cayman Islands and other offshore jurisdictions. It is incredibly expensive. It is convoluted, and it just doesn't, it's very inefficient, right? You should be able to set one of these up as quickly and as easily as you can set a startup up. And, one of our interests at A16Z is really trying to make sure that there's regulatory clarity and a pathway for startups to exist. So I think that overall, right, in addition to, the potential court system and stuff like that, I know that no one is probably out to represent the interests of lawyers in the state of Wyoming, but there will be, a lot of activity in that area of just, setting up these structures. There's, in addition to the filing fee, there's all sorts of things you need to do in terms of having a constitution, governing principles, and all of these sorts of things that lawyers will need to help with. And so there will be quite a boom there. With respect to the litigation, what I would say is that the real, I think, promise or opportunity for Wyoming is to, really take the lead on how these entities are litigated over. And so it likely, it could lead to additional cases, probably not in the short term as people are trying to get a grasp of how these entity structures work. But over the next 5 years, I would expect that a lot of the, how these entity structures actually integrate with the real world and existing corporate law will be determined by Wyoming. Now, that's a really huge opportunity. That exact thing is what led to Delaware having a very robust ecosystem. It is not the fact that, Delaware has favorable corporate law. which is why every single, startup that we invest in forms a C Corp in Delaware. It's because of their Chancery Court and the long history they've had of basically making decisions that give businesses a lot of clarity as to how the law is going to be applied. Because, even though this law is very long and 46 pages, it is still not going to resolve every ambiguity. So as a result of that, right, the real opportunity with respect to the court system is to begin starting the case law, right, and starting the precedent that is going to give businesses clarity in this space, and that represents a real economic opportunity. It obviously that kind of stuff takes a bit of time to develop, but already right now we're seeing, right, there are starting to be cracks in Delaware's monopoly, and that there are now several large corporations that are considering moving out of the state of Delaware, given some of the politicization that has happened in the court system there.
Other questions? Other questions? Okay. So with that then, Representative Western?
Mr. Chairman, if I may add, just going back real quick to Representative Conrad's question, just about, the one thing I wanted to mention is that under common law right now, if you have folks that come together, a group of people that come together for a common enterprise, that is technically a business organization. And with that come along those liability concerns that Mr. Jennings was talking about, where if we have this, it sets up some of those sideboards and regulates the risk, the liability, those kind of measures with this regulation. So I hope that can give you a little bit of extra clarity.
Representative Conrad.
Chairman Burkhart, thank you, and thank you, Representative. I was just curious, so if I may ask, we are trying to replicate the Delaware model?
For the
Mr. Jennings?
sorry, Chairman, for the court system or for this entity structure?
This entity structure?
This entity structure does not exist in Delaware.
Remember to adjust through the chair.
Sorry, Chair.
It's okay, both of you.
Yes.
Chairman,
Thank you.
thank you, please.
Yes,
Mr.
Chairman.
Jennings.
So the no decentralized unincorporated nonprofit association exists in the United States. Wyoming would be the first.
Okay.
The statute that it is based off, the unincorporated nonprofit association, which exists in Wyoming and has since the 1990s, that exists in, I think, 35, 37 states. So there is a similar structure, but this would be the first of its kind.
Mr. Chairman, thank you.
You're welcome. Okay.
Mr. Chairman,
Oh,
if I may
please.
introduce
Yes.
myself, we had a bunch of legal experts up here to really sufficiently answer these questions. I'm not a lawyer, my name is Brian Quintens. I'm the global head of policy for Andreessen Horowitz's crypto fund. Before joining Andreessen, I was a commissioner of the Commodity Futures Trading Commission for 4 years in the last administration, and was unanimously confirmed by the Senate in 2017, and was thrilled to join Andreessen because of the innovation that I saw occurring over the last 5 years when I was in the federal government. I think one of the questions that you may be asking yourself, or that were implied through some of the questions you've asked, or if we already have this digital LLC, why do we need this new digital nonprofit? And to me, some of those answers are because of actions that we have seen different agencies and departments take and Congress take in Washington over the last 3 years. If an entity in this space, a decentralized organization, decided to try to pursue the Wyoming digital LLC structure, the membership agreements of that LLC structure are securities agreements. Over the last 3 years, we have seen the Securities and Exchange Commission in Washington become the most hostile regulator and antagonistic agency towards this innovation anywhere in the world. And people that would be entering into those contracts would basically be signing their business's death warrant. Secondly, the Corporate Transparency Act was passed in the middle of the night and tacked on to a must-pass bill at the end of 2020, at the beginning of 2021, which allows the federal government to invade the privacy of members of LLCs and discover their identities and take their personal information. Both of those things, the Corporate Transparency Act, which is now online, as well as the hostility of the SEC, have basically rendered the digital LLC structure in Wyoming that it was such a leader on in trying to advance as a concept moot for this technology. If a organization decides to not register as an LLC and take their own chances, my former agency, the CFTC, has pursued a case in California where the organization, because it could not represent itself, it could not contract for representation, the agency knew it was going to get a default judgment, so it could throw in any legal theory that it wanted into those cases. One of the legal theories that it offered was that it had the power to hold any member of this organization, past, present, or future, liable for the actions of that organization at any time. It would be like the federal government holding me responsible for a $10 bill in my pocket for anyone that has ever used that illicitly in the past or anyone that uses that illicitly in the future. And so there is no viable pathway right now for innovators to do this responsibly, and we're thrilled to be here with you to consider that pathway and make it the first in the nation. Thank you.
Thank you. So with that, I'll open public testimony. Anyone else in the room wish to speak on Senate File 50? And I see no one online on my list. So, Mr. Lindholm.
Hey, Mr. Chairman, committee members, thank you very much. My name is Tyler Lindholm. I'm the State Director for Americans for Prosperity here in the state of Wyoming. We've got a tech and innovation portfolio that matches along with what you've accomplished here in the state of Wyoming over the last several years. Wyoming's great success in economic development has largely been driven by the legislature. It's the legislature's activities that have found ways to regulate an entity, to be inviting to these different types of entities. In a lot of cases, deregulation. This isn't a deregulation piece, but it's a new way for entities to be able to form here in the state of Wyoming. And at Americans for Prosperity, we hope that you'll support this as a means by which maybe we can get some new types of jobs out of this without taxpayer funds being utilized. And that's the biggest part about this, is we can do economic development without actually spending money. So I hope you'll vote aye.
Okay, committee, questions for Mr. Lindholm? Okay, thank you, Mr. Lindholm. Anyone else in the room? One last chance. Okay, with that, I will close public testimony. So, and Representative Western, you can come back up here and join us. Okay, committee?
Move the bill.
Moved by Larson, seconded by Conrad. Okay, so I don't want to go through a 47-page bill line by line, page by page. So just any suggested amendments that you may have, anyone? Any discussion on the bill? More than we've had? Question, Representative Heiner.
Thank you, Mr. Chairman. One of the troubling aspects of this is the fee that we're charging from the Secretary of State's office. We're seeing that we entered early and set the fee at $5, and this, I think, is a rule making within the Secretary of State's office, but I think maybe they ought to revisit that and look at what's surrounding states and what's more equitable for recovering their costs. $5 doesn't go very far right now. So maybe that needs to be adjusted, but that's outside of this legislation, but that's just a comment I have.
All right, thank you. Other discussion, comments? Okay, committee? Question being called. Mark, would you please call roll?
Representative Banks.
Aye.
Representative Conrad.
Aye.
Representative Heiner.
No.
Representative Knapp.
No.
Representative Larson.
Aye.
Representative Tarver.
Aye.
Representative Western.
Aye.
Chairman Burkhart.
Aye. Mark, I believe Representative Lawley has left a absentee vote, which is, please?
Aye.
Okay, thank you.
So
So,
7 ayes, 2 noes, do pass.
and that was Senate File 50, unincorporated nonprofit DAOs that we voted on. Thank you. So the next bill for our consideration is Senate File 66. And before we go to 66, just ask the committee and those present, did this format, which is a little different than what we normally do, work for everyone on this bill? Okay. So next one is Senate File 66. And do we have someone to present this bill? Okay, anybody from Select Water? Oh, come on up. Representative Davis, are you on Select Water?
You want to be.
Chairman Northrup, are you on Select Water? You're it. If you'd just identify yourself and that for the record, please, thank you.
Mr. Chairman, good morning. I'm Brandon Gebhardt. I'm the state engineer. I wasn't really prepared to present this, but I certainly can. I was involved through the Select Water Committee process. This came through the interim topic. But I can certainly try to walk you through and offer my.
If you would,
perception.
please.
Absolutely. So, Mr. Chairman, the changes that were proposed to the Senate were largely to address some concerns from some folks who were trying to utilize this tool to help secure their junior water rights. A lot of the discussion in Select Water centered mostly around our portion of the Colorado River, our Green River Basin. And so the intent was to clarify things in statute that they were running into questions on. So that was the intent of it. And so the First Amendment to the existing statute is on page 2 of the bill, lines 8 and 9. That is just to clarify what has historically been the practice of the state engineer. There was some concern that with the existing language, that it would not allow for the exchanges. It brought up questions as to what would be allowed. Some of the questions you could imagine without this new language in there could be interpreted that maybe it needed to be a transbasin diversion from a completely different water stream. Does it need to be a tributary to it? Like I said, historically, we have allowed within the same stream these exchanges to occur. So that just clarifies that. Excuse me. Mr. Chairman, the next changes on lines 17 through 19, that is just to sync up the language in the existing statute with other statutes and how we view and analyze injury when we review these. The next change on line 22, this was, I believe, an amendment in the Senate. I believe this was kind of a response to a petition that we have in front of us currently. This is to provide a public notice when these things are submitted to the state engineer's office. This particular case, we'd already intended and have the ability to have a public meeting on these. We intended to do that. But the bringer of the amendment wanted a little more certainty on that. So we actually, they brought an amendment. We actually helped with some of the language on it. So we were okay with this public notification. And then, Mr. Chairman, the last thing that this bill does is on page 3, line 23 is where it starts. What we heard through some of the testimony in Select Water was that the folks trying to engage in this tool were running into concerns from particularly the ag users that my existing water right, is it going to be protected? The answer was yes, but this provides a little more certainty to that. And I think that most people would be more comfortable with more certainty, and that was the intent of this last bit of the language. And in fact, some of the, I think probably the last 3 lines on page 4, 3.5 lines were taken from our existing temporary water use exchange or temporary water use agreement statute. So it syncs up with existing statute.
So committee questions for a good state engineer. Representative Larson.
Thank you, Mr. Chairman. Excuse me. So just help remind me, So just for a situational perspective on this, so this would apply, so if a industrial electronic producer wanted to use the right of water from another person in that same stream, this just clarifies that they're able to do that the way that it's historically been practiced.
Engineer Gebhardt?
Mr. Chairman, Representative Larson, that's right. That was a lot of the testimony that we heard through Select Water. It's a tool to allow an existing appropriator to be able to use the water that they're appropriated. In the case of a lot of the discussion that we heard, it had to do with concern in the Colorado River that if we were to go to curtailment, which is an interstate call on our portion of the state, they were concerned that their junior rights would not be sufficient to maintain their needs. And so this does provide a tool for them to be able to do that.
Okay, Representative Heiner.
Thank you, Mr. Chairman. Mr. Gephardt, thank you for being here. Water law is very complex, and it's something that takes years and a law degree and even more than that to be able to understand. So help me understand a little bit. Water rights are attached to the land in the state of Wyoming. So if I want to transfer some agricultural water right to an industrial application, the example previously was a trona mine or industrial. Help me understand, is it, is there some kind of a latch that we have to undo to be able to move it from the land to a industry?
Mr. Gebhardt?
Mr. Chairman, Representative Heiner, that's exactly what this tool does. It allows that change from, say, an agricultural use to an industrial use when it's needed, and then it allows, when it's not needed, for the original intent of the appropriation to be utilized. So agriculture stays in agriculture unless it's absolutely needed, and then it'll do this change. Sometimes they're permanent, sometimes they're temporary. The example we're talking about now, this would likely be only in times of a curtailment when their right would be called off. Would they exercise this exchange? The ag interest in this case would forego their use, and the industry would be continuing their use of water.
Follow up.
Follow-up, Representative.
Thank you, Mr. Chairman. So in a situation like that, is it possible with this bill being enacted that industry could go to a rancher or a farmer that has a water right for the land and offer them X amount of dollars and say, we want your water right, and basically shut down that ranch because it becomes a dry farm at that point with no water, but the rancher sees that there's more money in the water than in being out there every day working the ranch. So could this possibly lead to where industry comes into the state and buys or leases water rights from ranches and farms to be able to further the need for industry in their water?
Mr. Gebhardt?
Mr. Chairman, Representative Heiner, to be clear, these are just amendments to existing statute. So that already exists. One of the concerns that we heard through the testimony is to that point, that the concern to buy and dry agriculture for an industrial use was a big concern. I think that's why this is such a sought after tool, is because it bridges the gap that you don't have to come in, buy a ranch, move the water off, dry that ranch up to be able to use it. This allows kind of a middle ground where it's only needed, when it's only needed, would that ag have to forego its use. Other times, if it's not needed, then the ag could continue.
Representative Larson.
Thank you, Mr. Chairman. So, Director, excuse me. In your office, what is the process for processing? Is there an application for this, or is this just external from your office? Is it just from the rancher to the industry partner, or do they have to work through your office to have this happen?
State Engineer Gebhardt?
Mr. Chairman, Representative Larson, it is a process that goes through our office. Somebody that that chooses to use this tool would file what is called a petition to our office. We do an in-depth analysis of all of the things within this petition. We have rules that specify what needs to be submitted to us. We'll go through that analysis, and it will take an agreement between the two water users on their end. But yes, it is a process through our office for each of these.
Other questions? Any other questions? Okay. With that, Mr. Gebhardt, thank you. If you would hang with us, please. We may need help.
Certainly, Mr. Chairman, thank you.
So anyone in the room wish to speak on Senate File 66? Anyone in the room? Okay. I know we have two people on the virtual world, so just go ahead and admit both of them now. And we'll take Mr. Rachel first. Oh, there's Josh. Okay. Good. So Aaron, if you'd like to go first, please, name and information for the record.
Good morning, Chairman, and thank you. And good morning, committee members. I'm Aaron Reichel, 27-year employee of Genesis Alkali and 27-year resident of Green River. The trone industry must have water for operations. Without water, there is no trone industry, which puts 2,300 employees, a direct payroll of nearly $400 million and $100 million a year of taxes and royalties at risk. The likelihood of a curtailment on the Colorado River is a serious threat to the trone industry. I truly appreciate Select Water's review of this topic during the interim. As State Engineer Gebhardt mentioned, SF 66 provides important clarifications to the current statute. It does not contemplate policy changes. The clarifications found in Senate File 66 will provide confidence to a rancher that their water rights will not be impaired if they are willing to participate in backup water exchanges to the trone industry. This is an important bill for Genesis and the trone industry. If we don't encourage use of this exchange, the trone industry will be forced to pursue permanent separation of senior water rights from ag lands. We do not believe the permanent approach is good for industry, agriculture, or Wyoming, and that is why we support the clarifications in SF 66. I also want to address Representative Heinert's question about industry, kind of buying water rights, and as as State Engineer Gebhardt mentioned, that's already possible under existing statute. We do think the exchange is a good middle ground. There is, if you look at line 1, actually line 16, page 1 of this bill, as well as line 1 on page 2, our read of it is this tool is limited to water rights within the state. You have to have an existing water right in the state. And so it's really limited. The way we've looked at it is to industry and other agricultural or other junior water rights holders in the state. And so we think it's a great tool, and that's why we support it, support the clarifications to make it more comfortable for those that are willing to use it. So thank you, Mr. Chairman, and I'm glad to answer any questions.
Any questions for Mr. Reichel? Questions? Okay, Mr. Reichel, thank you. Okay, next up, Mr. Gemente, if you'd identify yourself and go for it.
Thank you, Mr. Chairman. Mr. Chairman and members of the Minerals Committee, thank you for allowing me to provide some testimony today. My name is Josh Gemente. I'm the Vice President of Government Affairs for HF Sinclair. HF Sinclair is the largest refining company in Wyoming. Between our two refineries, one in Casper and one in Carbon County, we process about 124,000 barrels per day of crude, which about 20% of that is purchased from the Wyoming crude slate. To echo Aaron's comments, if there is no water, there is no gasoline and diesel and jet fuel for the greater Rocky Mountain region. At our Parco refinery in Carbon County, we do run into curtailment issues. And so we, have been active in trying to secure long-term water rights that will allow the refinery long-term visibility into water, so we don't have to, in an unfortunate situation, curtail refinery operations, which are vital to the energy infrastructure of the state of Wyoming in the greater Rocky Mountain region. As written, we have no issues with Senate File 66. I'm not aware of any additional amendments coming from this committee. So we are good with the process. As the state engineer mentioned, you know, the amendment that was filed during the Senate hearing related to a public hearing is well within the jurisdiction currently of the state engineer, but as long as there's a process around that, we certainly don't have an issue. You know, as someone was mentioned, you know, there's a notion that that there would be a buy and dry sort of scenario. Really, for our operations, you know, when we would exercise our exchange petition would be the months of February, March, and April, which are in Wyoming non-agricultural months. And again, we have to replace the water that we take out of the river. So the ranching and agriculture use they'll be made whole. So we don't, again, no issue with the bill. With that, I'm happy to answer any questions that members of the committee may have.
Okay, thank you, Mr. Gemente. Questions, Representative Larson?
Thank you, Mr. Chairman. So, and this might be a question either one of you can answer, but does that notification timeline potentially cause some issues for you, especially if there's a call on the river curtailment issued? Time is money, and does this process need to go faster than the notification timeline allows?
So, Mr. Gemente, I'll start with you, and then if, Aaron, if you wish to respond also.
Mr. Chairman, Representative Larson, thank you for that question. Kind of in our experience, you know, as the state engineer mentioned, we're in the process right now of an exchange petition. By my watch, this has kind of gone on for about 13 months now. So, you know, again, getting long-term visibility into our water supply would be paramount for our operations. So, you know, we would be supportive of a quick turnaround here.
Okay, Mr. Reichel?
So, yeah, we support the language that was actually inserted, really working with Jim Magagna of the Stock Growers. We worked with him, kind of up with some language. It was a good balance, provided enough notification. We think notification is good because a good review of this means it's stronger, and we want to make sure when there is curtailment that we don't have to shut down our operation and send home our people for, you know, a bunch of weeks while we resolve it. So we think this is a good balance of amount of notification, gives folks the time to see it and raise issues, but obviously shorter is better, but this is a reasonable approach, I think.
Okay, thank you. Any other questions? Representative Heiner?
Thank you, Mr. Chairman. And this question can go to any or all three of the testifiers here. With the notification requirements for the exchange, you mentioned that sometimes this may be utilized in the spring of the year when water sources are low and ranching or farming is not needed for irrigation. But would this notification need to happen each time there's an exchange? Or would you just do one notification and then it's open-ended? Anytime you need to exchange, you can do that forever?
So, State Engineer Gephardt, I noticed you moving towards the microphone.
Mr. Chairman, I'll try to answer that. Representative Heiner, I believe the modification to this that we're talking about would provide notice that when an exchange petition is filed to the state engineer's office and it's technically sufficient, then we would provide notice that this exchange has occurred. And so that would be before a state engineer order to approve it. That would be the notification. I don't think that this contemplates that anytime the exchange is put into place and exercised, that notification would occur. It's just that prior to an order being made, that the notification would occur.
All right, thank you. Any other questions? Okay, so any last chance, anyone in the audience? Okay, with that, I will close public testimony. Mr. Gephardt, if you'd stay with us, please. Committee? Moved by Larson, seconded by Conrad. Okay, this is a nice 4-page bill, so anything on page 1, page 2, page 3, page 4. Any discussion on the bill? Yes, Representative Larson.
I think this is a good bill. It clarifies what's the current practice and look forward to support it. And I'd also like to manage it on the floor if that's okay.
No, that's not okay. Someone else has already asked to dip their toe in the water law area. So, sorry, you were a little late. Any other comments on the bill? Okay. Question being called. Mark, would you please call roll? We are voting on Senate File 50 engrossed, or I'm sorry, Senate File 66. As you can tell, the last one made an impression on me. Senate File 66 engrossed, water exchange amendments.
Got choked up. Need some water.
Yeah.
Representative Banks.
Aye.
Representative Conrad.
Aye.
Representative Heiner.
Aye.
Representative Knapp.
Aye.
Representative Larson.
Aye.
Representative Lawley is, I have hers.
And her absentee vote?
Aye.
Okay.
Representative Tarver. Aye. Representative Western. Aye. Chairman Burkhart.
Aye.
9-0.
All right, so Senate File 66 has passed the Minerals Committee, and Representative Conrad was just chomping at the bit to present this on the floor. So Representative Conrad, have at it when it comes up. Excuse me. The last bill, Senate File 50, I believe that Representative Western will be floor managing that. Okay, thank you. I forgot to mention that before. Thank you. Next bill for our consideration is Senate File 44 engrossed, limited mining operation amendments. So anyone here to present the bill? This was a committee bill, so I guess I could call on any member of the committee to present it. I see everybody is just jumping up and down to do that. So with that, I think I will defer to our good Department of Environmental Quality. I've asked Mr. Wentland and talked to him to give us a little bit of background as a reminder. This bill was passed out of the committee early in the process to bring everybody back up to speed on the bill, what it does, how it does it. So with that, and no offense, Director Parfit, but I will recognize Mr. Wentland to go ahead unless you want to make some opening remarks, Director.
Mr. Chairman, no, I think Mr. Wetland can handle it very, very well.
Nice delegation. Mr. Wentland, please proceed.
Mr. Chairman, members of the committee, I think with this bill, there's been some traffic on it, and I think it would be good to take just a couple of minutes and step back and understand what already exists in existing statute and is enshrined in that statute. And limited mine operations fall under Section 3511-401 of the Environmental Quality Act. And they've been around for decades in the statute. It is not new. In that existing language, the limited mine operations are set to 15 acres of affected land, excluding access roads, with written permission of the landowner or lessee of the surface for aggregate mineral categories of sand, gravel, scoria, dolomite, limestone, shale, feldspar, and ballast. It also requires that the notice must be provided to the DEQ and the state mine inspector 30 days prior to mining. A copy of the notice in item that I just referenced must be provided to all surface landowners within a 1 mile of the property boundary of the LMO, at least 30 days before commencing operations. The operator must notify the DEQ of the commencement of mining beginning within 30 days of those operations. The affected lands of the LMO shall not be within 300 feet of any existing occupied dwelling, home, public building, school, church, community, or institutional building, park, cemetery, unless landowner consent is obtained. And a bond must be filed with the DEQ prior to commencement for the required acreage of the disturbance. The operator must also then submit an annual report to the DEQ. That is what LMOs have today. So I know there's been some discussion about an operation in the state that's come up. If Senate File 44, for example, did not pass, it would not affect these existing statutes. LMOs would still be operable for those aggregate categories. I hope that provides some clarification, and I'll stop there to see if there are any questions.
Any questions for Mr. Wentland? Okay, none? Okay, go ahead, proceed.
Okay, Mr. Chairman, then on into the bill of Senate File 44. There were a couple of amendments. The first one is important. There was in the original bill that came out of the interim some language regarding counties and authorities between counties and the state. That language has been struck. In the engrossed version that you have in front of you today, that language is out of the bill. I believe that it's addressed those concerns of the county. So in your engrossed version today, that has been resolved, and that, to my understanding, is moot. I'm sure there's folks from the county commission here that could testify to that if there's questions on it. Moving on in that, Mr. Chairman, the first part of the bill that we'll get into is in page 2, and what that section between lines 8 and 13 and page 2 of the bill, and the engrossed version does, is it strikes out the existing aggregate categories that I previously referenced, and it adds in any non-coal minerals except minerals regulated by the United States Nuclear Regulatory Commission and minerals regulated by the state under Article 20. Simply put, it expands the LMO categories to all non-coal minerals with the exception of radionuclides. Okay? Moving on, Mr. Chairman, to page 3 of the bill. This is where we get into the bond, and I know there's been some discussion and questions about the bonding, and I want to make sure that we're clear as we walk through this. So I'm going to break this down into some sections. Lines 11 and 12 reinsert those aggregate categories for the purpose of per acre bonding and protection of those existing categories of aggregate minerals for the ability to per acre bond. When we move into line 14 and 15, those rates were changed from 2,000 to 5,000 for loose material, which is non-quarry. And then in lines 17 and 18, it was adjusted for quarries from 3,000 to 7,000. And then there's a key provision here that I think some folks may have missed in reading the bill. It says, or those aggregate categories have the option of providing a full cost engineered bond, of which the agency would accept those per acre rates or the engineered bond, whichever is most appropriate and less for the operator. What I will say with those $5,000 and $7,000 adjustments to the current rates is that wasn't pulled out of thin air. We looked at inflationary rates, fuel costs, mobilization and demobilization costs, and then the differential between the loose material and the quarry is for explosives costs. That's where you get that difference or a higher rate for the quarries. We're not married to those numbers by any stroke of the imaginations. They were developed from a mathematical perspective only. If there are adjustments that folks want to propose, this is not something that we were set on. What I will say and add to that, though, for the purposes of discussion, is we recently bid 2 projects in northeastern Wyoming that were forfeitures. If you use the existing $2,000 and $3,000 per acre rate, I was $19,950 short on one project and I was $5,000 short on the second project. If you apply the the 5 and 7,000 numbers to those projects, I was $50 short on one project, $1,000 long on the other project. So just for scale, that's not to say that one is better than the other. I just wanted to provide that to the committee so that they know we just didn't derive these numbers out of thin air. Okay?
So, Mr. Wetland, it's fair to say the choice here with the bonding amounts is who ultimately pays, correct?
Mr. Chairman, that's correct.
Whether it's Mr. Wetland, whether it's the state or the bond, correct?
Mr. Chairman, that's correct.
Okay, thank you.
And then the last part of the bonding piece is, and we recognize for the other new categories of non-coal minerals, that could be gold, copper, some of those materials, there is the potential for acid-forming materials in those, and we felt that it was only appropriate to use a full cost bond in the event we may need to add a clay cap or some additional mitigation for those minerals. So we were trying to be protective of that resource by saying you have to have a full cost bond for those actions. Mr. Chairman, then we move into, at the bottom of page 3, line 23, and then on to line 1 and page 4, we changed that from 90 to 150 days. In the current statute, it says that the administrator has the right to adjust the bond once the company would to dig into the material. And if they find something like a water source or let's say an acid-forming material, we have the right to adjust that bond upward to cover for that. We extended that time frame to 150 days because 90 days has been a little short by the time somebody mobilizes and starts to dig. We just made that consistent. That also, the 150 days is derived from the fact that a technical review on a large mine is 150 days, so it somewhat standardizes that time frame. And then, Mr. Chairman, on line 6 there's an adjustment to the 45 days. Again, that's for consistency. That 45 days is the same 45 days used in a director's bond letter. So it's just a consistency item from the 30 to the 45 days. Mr. Chairman, from line 7 through 9, I think there is some, again, I've heard some concern over this, and I want to just spend a little bit of time on it. It's saying that all limited mining operations existing before July 1, 2024, those on the books today, shall file bonds in accordance with this subparagraph no later than August 15, 2024, or simply put, July 1, add 45 days, that's how you get to the August 15 deadline on this. I think, Mr. Chairman, there's an opportunity here that might be beneficial to folks as well as the agency. I'm not sure we could process all those bonds in 45 days. And it might be worth considering some language change here, that at the word shall in line 8, change that to shall file bonds in accordance with this subparagraph within 1 year and in concurrence with the required annual report, but no sooner than August 15th, 2024.
Mr. Wetland, you're going to have to repeat that again unless you have it in writing as.
Mr. Chairman.
Realize you're the gold standard on amendments.
I failed my gold standard because this was something I considered this morning, and I'll reread it slower for you.
Please slowly, because staff needs to get that so we can have these correct for floor debate.
Okay, we are on page 4, line 8, at the word shall. Okay, that language would be shall file bonds in accordance with this subparagraph within 1 year and in concurrence with the required annual report. but no sooner than August 15, 2024. Mr. Chairman, what that language does is it gives folks a little bit of time to adjust to the, whatever those changes are. And if they choose to use a engineered calculated bond, it gives them time to do that. It also gives us time to, from the agency to review those, and it does that over a 1-year phase-in process.
Okay, thank you. We'll address that when we get to amendments. Go ahead and proceed.
Okay, Mr. Chairman, we're now on lines 13 and 15. And those are changes in the reporting time frame for the operator to notify the administrator for commencement of reclamation when they're getting ready for pit closure, and notify and plan for commencement of that reclamation within 45 days. That used to occur within the annual report once a year. It's resulted in some lag time in getting reclamation completed and getting on the books, and this just sets a defined time frame around that. And the key word there is plan for. We're not saying you have to start it, because we know in January you may not be able to start it, but at least plan for and give us a schedule. Okay? Moving on, Mr. Chairman, the lines 21 through 23 on page 4, and then line 1 and page 5. What this section of the bill does is it uses the expanded language that we talked about earlier as far as expanding the mineral categories. Line 12 on page 5, this is a reference to the required subsection K. This comes into the 5-year terms that we'll talk about in a minute, and it just is the cross-reference for that. Line 23, page 5 is a typographical error. Then we move to page 6, which is lines 5 through 11. What this section of the bill does is it says, right now there are 3 permit categories. There's LMOs, small mines, and regular mines. We have found that the small mines have both overburden and tonnage limitations on them. And in a lot of cases, those are restrictive enough that they're not able to meet the mineral demand out of those pits. And it would be better served to just be in a regular mine, and that also is somewhat of a regulatory reduction and streamlining of the permitting. So what this section does is it grandfathers existing small mine operations. If you have one today, you get to keep it. And going forward from July 1, 2024, the agency would not issue small mine permits. Going forward, it'd just be the regular mine permit. That's what that section does.
So, Mr. Wentland, I want to back up on that, just so everyone understands. In effect, after July 1, 2024, the only permits the department would issue would be for mining, period, done. We do away with the LMO section and do away with the small mines, or we keep LMOs and...
Mr. Chairman, LMOs stay.
Okay.
They're in the statute 401, they stay, as they are today.
Okay.
Mr. Chairman, small mines are the only permit category, and LMOs are a notification, small mines are a permit. Small mine permits would not be issued after July 1, 2024. We would still issue regular mine permits after July 1, 2024. So it would streamline from the current status of LMO, small mine, regular mine, and change that to LMO and regular mine.
Okay, I just want to make sure now, because in our wording, and this is a committee bill, so I can say that, in our wording, we are not real clear on that. Now, is that in rule, or how do you break out LMO, small mines, regular mines? Because I couldn't find it in statute.
Yeah, Mr. Chairman, this section of 401 is what authorizes small mines permits, and then they're issued through the rule. So this does make that change and makes it clear that, and it's important too, if you have a small mine, you get to keep it today. It's just only going forward from July 1, 2024, where we don't issue small mines. I believe this language is pretty clear for that in the statute and how it applies to the rule. We're comfortable with that language.
Okay, all right, thank you. So, excuse me. So you said that LMOs require a notification, not a permit. Does any of this change that requirement? Are you requiring a permit now for LMOs?
Mr. Chairman, no, it does not change the existing language in an LMO.
Okay, thank you. Go ahead, proceed.
Mr. Chairman, lines 19 through 20, page 6. Because we're bringing on new minerals, we just wanted to make sure that mineral reporting for revenue purposes is included in the statute, and that's what those lines do. And then this is on the renewal piece, and Mr. Chairman, I think there's been some discussion and some traffic on this as well. In the current statute in 3511-401, and I am in E6, then large E, it's actually page 78 of the Green Book. That's where the 5-year term renewal provision exists in existing statute. That was put in about 5 years ago. When we put that in a number of years ago, the provisions for a renewal were never codified in the statute. We felt that codifying those renewal provisions was important because we're coming up on that 5-year term, and we think operators should probably have certainty as to what those renewal provisions are. That's what those lines 22 on page 6 through 23, and then lines 1 through 23 on page 7, and on over to line 2 and page 8 do, is they codify those reasons that a renewal would occur and be automatic and give the operators certainty. Okay. Then moving on to page 8 in lines 17 through 22. Currently for a regular mine, it's a 5-year bond release requirement. LMOs have always had a 2-year requirement. We wanted to make sure that these LMOs, because we're eliminating small mines, we just wanted to make sure to codify that existing practice of those 2 years for LMOs going forward, and that they wouldn't fall under the regular mine 5-year provision. There was an amendment in the Senate side of the bill that also added, and I'm going to just quote it out of the line here, after consultation with any affected surface interest owner. That is our existing practice. We even have a form for that. It was a friendly amendment on the Senate side. It was a good clarification and a good catch, and the agency supports that change. And then on page 9, lines 6 through 10, again, this language is the same as what we just had. It's just codifying those bond release practices so that the two statutes coordinate and cross-reference correctly. Section 2 just has the council, the Environmental Quality Council, doing the rulemaking, and I believe that there is no fiscal appropriation on this bill, so there's no provision there. And Mr. Chairman, with that, that's the bill, and I would stand for any questions.
Okay, questions for Mr. Wentland? Committee, questions? No questions? I guess all of you perfectly understand the bill. Representative Heiner.
Thank you, Mr. Chairman. Mr. Wentland, could you explain, we've had a lot of traffic about Casper and some activity there. Could you explain how this bill affects that development or what's going on in Casper?
Mr. Wentland?
Mr. Chairman, it does not. As I stated earlier, if this bill did not pass, the LMO provisions are already enshrined in 3511-401, and that project would move forward under those provisions. Actually, what this bill does is it potentially adjusts the bonding rates, which might be helpful in that scenario.
Thank you. I just wanted to get that out. All right. Other questions? Representative Tarver.
Mr. Chairman, thank you. Mr. Wetland, a couple of quick questions here on the bonding amount. So most of these aggregate products that are being sold, are they not taxed? That's question one.
Mr. Wentland?
Mr. Chairman, I'm not a revenue expert. I believe they do, depending on the mineral ownership. Let's just say in a state section, there's a mineral royalty that probably applies here. Again, that's not what our office does on that, but I'm sure that between private corporate operators on private mineral, I'm sure there's arrangements there for royalty.
Follow up?
Mr. Chairman, I guess more directly, we do charge sales tax on products being sold.
Mr. Chairman, again, I'm not a revenue expert here and the taxation on those. We're just we just do the permitting and that piece of it. I'm sure there's tax and tax spinoff that does come off of that. I think the Wyoming Mining Association or the Association of General Contractors may be able to better answer those questions.
Okay. Thank you, Mr. Wetland. So,
Follow up to that, a different slant.
okay, let me address that question first, though. All the minerals that come out of the ground that are sold, so you mine, quarry, 1 million tons of gravel, and you sell it to someone. Yes, there's sales tax on that. And there is also severance tax on all the minerals that have been added in here. It's already in statute that there's a list of minerals that pay severance tax: coal, uranium, all of those. And then there's a catch-all that says all other minerals. And if I remember my tax law correctly, it's 2% right now for all those other minerals. So if someone has a small mine to mine cobalt, they would pay the severance tax on the value of the cobalt at 2%. Does that answer that part of the question for you? Okay, go ahead, proceed with your follow-up.
Mr. Chairman, thank you. So that being said, these mines have already paid sales tax, severance tax, all these other taxes. And I really feel that this extra bond money would actually hurt them. Some of the smaller operators, especially generational operators that have inherited these mines. The gravy's already been mined out. And I guess my question to you is, what would you think if we perhaps didn't raise those bonds and maybe give some of these older operators? I just feel like this could really hurt these older operators. And I have got a lot of emails on this, and they're very concerned that it would make them unprofitable at this point.
Mr. Wentland?
Mr. Chairman, we're neutral to what the desires of the committee and the legislature are on that. The only thing I would say is I would certainly keep the provision for the full cost bond option. That's never been available to those operators, and in some cases, that could potentially be even lower than the existing numbers. So I would encourage you to keep that provision, but if the committee and the legislature decides to alter those rates, I'm neutral to that.
Okay. And Representative Tarver, a few years ago, we passed that provision for a full cost bond for the coal mines, which my understanding is they really like, and we have a number of them participating in building that full cost bond fund for their mines. This extends that, and that's a policy decision, extends that capability to non-coal operations. So I would agree with Mr. Wentland. That's just a statement from me. And as for the bonding amounts, that's a policy decision for this committee to make and for the overall legislature. Hope that explains it for everyone. Okay. Other questions for Mr. Wentland? Representative Parfit.
Thanks for the promotion to the legislature.
Director. Sorry. It's been a long 2.5 weeks.
Mr. Chairman, just on that point on the bonding, I just want to further point out that if the bond amount isn't raised, what we're seeing is that we don't have the resources to cover when there's a forfeiture on the bond. And so in some way, we would need to either adjust the bond amount, or we'll have to come to the legislature for a request for an appropriation to cover those costs.
So, Director, approximately, and make a guess, because you don't have this number, I know, in your head, and may not have it. Approximately how many operations do you feel you would have to exercise the bond on where there's a forfeiture? Just a rough idea.
Mr. Chairman, I believe Administrator Wentland has that in
Oh,
his mind.
okay.
Mr. Chairman, right now I have 14 forfeitures pending. The cost differential has ranged anywhere from 5,000 to 270,000.
Okay.
In shortfall.
All right, so Mr. Wentland, that is money that will come out of Department of Environmental Quality's budget, am I correct? Do you have an account for that money that that gets appropriated, or do you have to come back to the legislature for an appropriation?
Mr. Chairman, we would have to come back to the legislature for an appropriation, but I will say that some of these projects have been funded with what we call supplemental environmental project funds. This is where there's a compliance action that's taken, and a entity has the opportunity, if they so choose, is to participate in what's called the SEP, and provide monies in the SEP for that purpose.
Okay, thank you. Evening. Excuse me, other questions for the director or Mr. Wentland? Okay, thank you. So with that, I'll open it for public testimony. Anyone from the governor's office? Any state agencies? Okay. Any legislators in the room wish to speak? We have one for a change. The comment made up here was, oh boy.
Oh, boy.
So, Chairman Northrop, please proceed.
Thank you, Mr. Chairman. I have some questions about the plan and as it exists, as they're talking about having an engineered plan. Does the engineered plan consist of a survey? As you know, surveys on any piece of ground are very expensive relative to other costs. And so that would drive the cost up. And I'd also like just to have maybe, if the committee could delineate what the engineered plan is, just for the public's knowledge, so that everybody's on the same page. Thank you.
Mr. Wentland, you wish to address those? Proceed.
Mr. Chairman, the answer to that question is pretty straightforward. Since 1996, the agency has used what's called Guideline 12. It's a guideline to calculate an engineered bond. For non-coal, it's 12A. That guideline has been updated and reviewed annually, and it's updated for inflationary costs on an annual basis, and that would be the basis for how the bond would be calculated.
Thank you. Okay. Other comments, Representative Chairman?
Thank you, Mr. Chairman. I guess 12A doesn't mean anything to me because I'm a layman in this area, so if you could have the good man at least go through and tell us.
Mr.
I'll look
Wentland,
in
please.
myself.
Mr. Chairman, that category calculates in what a mobilization, demobilization cost would be. And if you're knocking down a small high wall, what a small dozer production would be for per hour rate for the hour rate on the dozer, an hour rate on the operator. It has a fuel cost built into it, and it's pretty straightforward. On these smaller pits, you're basically knocking down a small wall with a dozer. You're respreading some topsoil, and you have seeding and revegetation costs in that. It's really a pretty straightforward calculation.
Okay, thank you.
Thank you, Mr. Chairman, for indulging me.
You bet, Mr. Chairman. Any other members of the legislature wish to speak? Okay, with that, members of the public. Ms. Little, please identify yourself. Again, for the record, we know who you are, but we need to keep track of these things.
Sure. Thank you, Mr. Chairman. Good morning, Mr. Chairman, members of the committee. My name is Kelly Little. I'm with the Associated General Contractors of Wyoming. AGC of Wyoming is appreciative to the DEQ and this committee for the commitment to reduce the burden of overregulation and find ways to be more streamlined and efficient. The thorough review of these statutes has identified common sense changes that will benefit both the state and the industries that work here. One change on our radar, as many of you are aware, is the bonding rate change. Our members are actually comfortable with the change in the bonding rate. We feel it is helpful for the department to have the resources needed to assume reclamation if it comes to it. We feel it's a fair amount of increase that will be settled policy for the foreseeable future. However, we have heard the concerns from some of the smaller operators, and so we're also supportive if this committee feels there is a need to make a change there. We're also supportive to the change in the small mine classification. Again, we just feel that this reduces complicated policy and streamlines the statutes. We're happy to have had the opportunity to work on this over the interim with this committee and the department, and I will stand for any questions.
Questions for Ms. Little? Questions? So, Ms. Little, question. We've talked about bonding, which means you in effect buy an insurance policy to reclaim. What would be the difference in, say, call it the premium, if between the, say, 2,000 and 5,000 and the other one? What would be the difference in that, if you know, change in the cost of that bond?
Mr. Chairman, I don't have the information right now. I would have to get back to you on that and ask some of our members. They're kind of the experts in this, but I'm happy to get that information for you.
Okay, thank you. If you could.
Sure.
And forward it to the entire committee.
Sure. Yep,
Please,
I'm
thank
happy
you.
to.
Okay, any other questions for Ms. Little? Okay. So, Mr. Detai, you know the routine.
Thank you, Mr. Chairman. Members of the committee, Travis Detai with the Wyoming Mining Association in support of the bill. And a lot of the discussion has been around the sand and gravel operators. Those are not my members. So where our interest is in this bill is the opportunity for the new mineral sectors to come online, whether it be gold, copper, nickel, lithium. We have those there are a lot of claims out there right now, and I might get the number wrong, but I think in testimony before the other body, Mr. Wentland alluded to that the BLM has somewhere along the lines of 4,000 claims for these minerals, and I may have gotten that number wrong, and I would stand corrected if you wanted to. But this is happening right now, and what this does by expanding the LMO to those other minerals, those non-coal minerals, is it's giving us a real opportunity to take advantage as a state and as an industry to develop those. I think that when you get some of these new sectors come online, they can work under the LMO. They can get into production faster. They can develop that landowner operation or landowner. What's the word I'm looking for? The relationship, the landowner relationship. And then when it comes time, they move into a general mining permit that goes through the full public comment period, just like any other a mining operation. And it starts, it enables us to start production, generate revenue, and create jobs. So this is good for my sectors. We're agnostic on the bonding because I believe any of these new minerals coming in have to be full cost bonded anyways, which is a good thing. And, we just see this as a real opportunity to start taking advantage and develop that hard rock sector that we haven't had for decades in this state. And, with this piece of legislation and with the non-coal blasting regulations that this body passed, these are two really significant pieces of legislation and are really setting up the state for the future. So, Mr. Chairman, members of the committee, in support of the bill, and, we would, if the committee chooses to adjust the bonding rates for my sand and gravel friends, we're perfectly fine with that. We want to see this bill pass. So thank you, Mr. Chairman, and I would stand for questions.
Questions for Mr. Detai? Any questions? Okay, Mr. Detai, thank you. And now we have the county commissioners. Again, you know the drill. You've been here before. Please, Mr.
Yes,
Novotny.
Good morning. Bill Novotny on behalf of the Wyoming County Commissioners Association. As you are aware, initially we opposed this bill because of that county-specific provision that was added. We were successful in removing it on the Senate side, and we would ask you to continue to keep that particular position out of this bill so that this bill can move forward. Otherwise, we really have some current concerns that can be addressed in pertaining to some bonding questions. But overall, we would just ask you to please hold on that Senate position of striking that local control option.
Okay, thank you. Commissioner?
Thank you, Chairman and members of the committee. Some of us have been here before, but some of us have not, so I'm a little
Okay,
bit nervous.
we're friendly.
I apologize for that. But
Please.
with that,
Who you are.
excuse me, Lloyd Teal, Park County Commissioner from Park County. There's still some concerns, and I believe all of you have received emails from our president of the Wyoming Association of County Engineers. And one of our concerns I left is it was possibly an oversight because we were so concerned about the counties being left out of decision-making. And I'd greatly appreciate we do amending that as in the committee and in the Senate to get us our input back in on the county. But however, the concern left is the overall cost of mainly to the bonding and some of the rules that would be put on the local developer. And these costs are going to be added right into counties use materials from these small operations for road maintenance throughout the state, especially in Park County. One of the things that I don't believe is quite understood on the bonding rate, and I fully understand what we're trying to do here, is streamline the reclamation process and get it more efficient for what the actual costs are. Excuse me. However, the amount of the increase is going to possibly run some of these smaller operations from continuing, and it may actually have a negative effect and have some of them walk away from their permits and not be able to continue, because pit permits and gravel sources that are out there that are 15 years and older have even as low as a $500 reclamation bond. In the past, every time it has been raised, if you were permitted for 5 acres at $500, that was just $2,500 bond. And as you guys understand, it's just an insurance policy, as Chairman Burkhardt had mentioned. So those policies cost a lot more for smaller amounts. So operators have chose to self-bond. You get a CD, and you put it in the name of the DEQ of the state, and then it's theirs for the reclamation. This bill makes all of those have to come from $500 to $5,000. So if many operators aren't going to be able to afford that, and I'm afraid it may actually cause more reclamation operations for the state. So that's one thing, that if possibly we can, instead of retroactive everything backwards, any continued or moving forward could be 5,000, I believe would be a good number, or an expansion of an existing mine could be the $5,000 would be a possibility to hopefully satisfy some of these smaller operators. We do support the 1 year time frame in which was mentioned earlier, because there's no way that most of these operators could get these new bonds, whatever they might be, if they are less than 5,000 or if they're left at that. But having 45 days, you can't get that done in that amount of time. Especially, I do like the ability of an engineer's estimate. However, the smaller guys don't, that expensive surveying and an engineer's certified estimate of what it would cost to rebond may not be feasible for the smaller operations. I just want to reiterate how important these small mining gravel operations are to the counties out there. And it's going to cause them to definitely raise their overhead cost to the county, cost to the taxpayers. Thank you, and I'll answer any questions.
Okay, questions for Commissioner Heel? Questions? Okay, thank you, Commissioner. Anyone else in the room? Public testimony. Mr. Fair, I believe you originally were online and you've decided to show up. Thank you.
Yes, thank you, Mr. Chairman.
Please proceed.
Members of the committee, my name is Chris Fair. I'm the manager of Prism Logistics based out of Casper. I live and reside in Gillette, Wyoming. As we know, we say Gillette, inherently Wyoming. However, yes, sir, I left at 0300 this morning to be here, and in case the weather shut me down, I was enrolled online, but was happy to make it. In front of you today, in support of the file, in particular, Mr. Administrator Wentland did an exceptional job of reviewing the history and your guys' good work, the committee's good work, in addition to speaking to discussions related to bonding, landowners, dealing with the full cost bond. As far as Prism Logistics and the operations that we operate, we support and stand with the Land Quality's proposal for the bond adjustment, in particular the opportunity at a full cost bond. My career experience as environmental engineer, mining engineer, leading a company, that full cost bond in 12A is an excellent tool, and can be completed by many different types of operators. So support of the file, and appreciate you guys' time.
Questions for Mr. Fair? Any questions? Mr. Fair, thank you, and thank you for traveling here to be with us this morning. We understand that can be a logistics nightmare sometimes, so thank you again.
Yes, sir. Thank you.
So anyone else in the room? Okay, with that, I believe we have one person online, Ms. Anderson. If you'd go ahead and admit her, please.
All right. Thank you, Mr. Chairman. Appreciate the time this morning. Shannon Anderson on behalf of Powder River Basin Resource Council. So first off, we want to recognize that there are some pieces of Senate File 44 that we do support. As we mentioned in testimony during your Rock Springs meeting, we appreciate the DEQ's proposed improvements to the bonding portions of the LMO statute. As Mr. Wentland highlighted this morning, there have been bond forfeitures that have ran short for past LMOs, and we certainly don't want that to continue to be a problem for the state. However, these reforms highlight the problem with bringing in new mine types into the LMO permit exemption process. LMOs are not regulated as mining permits. They are exemptions to mining permit requirements. So skipping straight to a permit exemption process for types of mines that have never been permitted and developed in Wyoming before, such as rare earth elements, lithium, gold, copper, this is a cause for concern. Industry has not pointed to any issues with receiving a small mine permit, and that process is currently available under the statute. It is still significantly streamlined compared to a regular mine permit process. So as we talked about in Rock Springs and Gillette, LMOs were designed to facilitate short-term, time-sensitive mining projects, like for instance, a YDOT gravel pit that needs to be up and running for the summer construction season. LMOs were never contemplated to replace mine permitting requirements for other mine types. And for these reasons, we would urge you to vote against Senate File 44. Nevertheless, we understand that both industry and DEQ are pushing this bill forward. And so in the spirit of compromise, we have offered 2 amendments for your consideration this morning. My colleagues in Cheyenne have distributed them to you as a handout, so you should have them in front of you. The first amendment we recommend provides that there would be a comment period for LMOs before they are authorized by the DEQ. Again, we don't say permitted for LMO since there is no permit. So authorizing should be the correct phrase, and my apologies for the typo in the proposed amendment language. It should read authorizing, not authoring. We know public comment opportunities serve to mitigate conflict by allowing neighbors to proposed operations the ability to ask questions or raise concerns, most of which get answered by the DEQ and the company. LMOs don't allow for any public participation. So here neighbors to propose mines get a notice, but they can't do anything about that notice. Some companies are willing to meet directly with the neighbors, and our organization has facilitated such meetings in the past, but the role of the DEQ is absent. Public participation is a core component of the Environmental Quality Act because we know public comment makes agency decisions better. The second proposed amendment brings in a core requirement of small mine permits into LMO authorizations. Wyoming has a noxious weed problem, and mine reclamation should not contribute to that problem. Again, these standards are required for small mine permits, and it should not be an issue for LMOs to meet these requirements as well. Since there is not a permit, it's helpful for these requirements to be set forth in the statute itself. And with that, Mr. Chairman, I'd be happy to answer any questions you may have on the amendments or generally about the comments I presented to you this morning.
Okay, any questions for Ms. Anderson? Anyone? Question? Ms. Anderson, thank you very much. Thank you for the written comment, the written proposal. It makes our job a lot easier.
Thank you, Mr. Chairman.
Last chance, anyone in the room? Okay, with that, I'll close public testimony. Committee?
Move the bill.
Moved by Conrad. Seconded by Lawley. So we'll just go through this one. It's not that long, page by page. So page 1, comments or amendments. Page 2. Page 3, Representative Tarver.
Mr. Chairman, I would like to entertain the idea of perhaps putting a grandfather clause in there for some of our, I don't even know where to put it, how to do it, but just a thought.
Okay, so are you recommending an amendment or is that just a comment?
More of a comment.
Okay, more of a comment. Would that be something you'd be interested in doing for Committee of the Whole? Okay. Anyone else on that issue? Any other amendments on, proposed amendments on page 3? Okay. Page 4, Representative Larson.
I'd like to move an amendment on page 4, line 9, as presented by DEQ. After subparagraph, insert within 1 year and in concurrence with the required annual report, but no sooner. And then we would strike not later, and then it would just be read, but no sooner than August 15th, 2024.
Okay, seconded by Knapp. Mark, do you have that?
I had that on page 3.
Okay, actually, I believe it is page 4 on our comp. Line 9, page 4.
Tanner has it.
Okay, Tanner, you have it.
We'll adjust
Okay,
it.
all right. I just want to make sure. That's why we do this. We don't want to do incorrect amendments, okay? Any discussion on that amendment? Representative Lawley, you weren't here for that.
Thank you, Mr. Chairman. I just would like Representative Larson to just repeat it for me. I didn't quite catch all of it. I got
Okay,
the.
Representative Larson, please.
So, Mr. Chairman, page 4, line 9, after subparagraph, insert within 1 year and in concurrence with the required annual report, but no sooner. And then we would strike not later, and then it would read then August 15th, 2024.
Okay, you have it. Okay, thank you. Any discussion, further discussion? All in favor of that amendment, please say aye. Aye. Opposed, no. Okay, amendment is adopted. Page 5. Page 6. Page 7. Page 8. Page 9.
Question.
Okay, well, just one moment, please. Okay, we have a proposed amendment. If anyone would like to put that forward, 2 proposed amendments. Okay. All right, seeing none, then committee?
Question.
Question being called. We are voting on Senate File 44 engrossed limited mining operations amendments. Mark, please call the roll.
Representative Banks.
Aye.
Representative Conrad.
Aye.
Representative Heiner.
Aye.
Representative Knapp.
Aye.
Representative Larson.
Aye.
Representative Lawley.
Aye.
Representative Tarver. Representative Western. Chairman Burkhart.
Aye.
9-0, do pass.
Okay, and now who would like the floor manage this one? Larson? Representative Larson, would you like the floor manage this?
I will do my best.
And you'll be assisted by the rest of us. Okay. All right, that concludes this meeting. We are 1 minute ahead. So you have 1 minute to get to the floor. Thank you all. Thank you for being here in person. And Mr. Farr, again, thank you for the long drive and for being here. We appreciate it.